rules, laws, rules, statutory provisions that guide or govern issues, bordering on gender-based violence and how they ought to be treated. And so, if you look at my slide, it's an overview of it's a slide. The slide is 16. It's just 14, basically 14 slides, but containing concise content, that would guide our conversation. Now, if you look at the introductory part of our discussion, we want to look at just basically an overview, because I'm very sure previous discussants or tutors must have actually, touched on what gender-based violence is. Now, to just give a very simplified or simplistic, overview of what gender-based violence is, you're looking at the violence, meted out against a particular gender. And in most cases, these actions that are being meted out against the victim constitute an offense under our laws. But unfortunately, more often than not, we discover that women or the feminine gender are almost always the most hit when it comes to gender-based violence. And it is gender-based violence because it is an act, a crime, violence perpetrated by one gender, in most cases the masculine gender, against the feminine gender. But of course, it could be vice versa. I recall delivering a paper on this same topic, and I decided to stick to the other side of the discourse. In other words, representing the masculine plight. And I think I tagged that topic, gender-based violence, balancing the discourse. So in the meat of that discussion was centered on the plight of men who are equally, that's male victims, who are equally male victims of gender-based violence. And so we'll also be looking at forms of gender-based violence. So let us look at the traditional Nigerian setting, because I always like to contextualize the topic to the things, the happenstances, the realities in our society. We didn't come down from the heavens, did we? We are products of, peculiar societies, located in specific regions, isn't it? And we see these things happening on a daily basis. But the most typical form of gender-based violence, as identified by the UN, could be physical, could be sexual, could be emotional, could be economic. Now you ask me, gender-based violence, why would it even then take the economic dimension or form, or emotional dimension, when in most cases the one that we are mostly familiar with are the physical and sexual forms of of gender-based violence? Yes, it's possible that a perpetrator or a particular gender can enslave or can subject the other gender or the victim through, economic schemes designed to make that victim overly dependent and, enslaved or stagnated economically. What that means is the scheme is to ensure that that victim, the gender, in most cases, the woman, is not encouraged or empowered to be financially, independent, to be self-sustaining or self-reliant. In other words, everything that has to do with that victim's well-being is determined by the perpetrator, the other, offender, the offending gender, isn't it? That's basically what constitutes the economic side. And of course, emotional, vis-a-vis the stance, the domineering, that's like I argued in one of my sessions here, that in some sense, the mainstay of a particular form of domestic violence known as sexual or marital rape is what is power and control or domination. So when it comes to the emotional form of gender-based violence, you could see it, exhibited in several forms. And I must say this without, without any fear of contradiction, that for the emotional form, ladies you can argue, are mostly the guilty parties, or the feminine gender is mostly the guilty party. Why? Because we realize that emotional, violence has been deployed by the feminine gender in so many ways to get at the masculine gender. But of course, like I said, it is not a one size fits all approach. It could be either way. Men equally deploy emotion, or play on the emotion of the feminine gender, just to ensure that they maintain control and power over that victim. So these are the basic forms of gender-based violence. There could be more. I think that if you go beyond that, you will come across concepts like IPV, intimate partner violence. Intimate partner violence is also a form of gender-based violence. So now, and we do know, before we go to this slide on legal frameworks addressing gender-based violence in Nigeria, we do know the negative impact that gender-based violence have had on societies, especially traditional African societies, even modern African societies. And it is a silent killer and has become a scourge, such that it happens every now and then. It has become a recurring decimal, as aided by certain schemes and practices, which we shall unfold, or we shall be unfolding in the course of this class. So we'll move on to the legal frameworks addressing GBV in Nigeria. Now, what are these legal frameworks? We talk about the fact that laws exist. In fact, Nigeria as a country has a broad base, corpus. We call it legal corpus. That is, we have so many laws addressing specific issues or menaces or problems in society. Why is it that there are too many laws, yet it appears that these laws do not have, are not effective enough, in addressing the scourge, for which they were enacted? And so, in the course of this class, we shall be identifying what these specific legal frameworks are, and their scope, what they entail, the relevant clauses within them that seek to address the menace of gender-based violence, and to a very great extent, why they are not that effective as they ought to. So next slide, please. And before we move on to the next slide, do we have any questions whatsoever? Are we following? Am I audible enough, please? Am I audible, please? I need to know if I'm audible, because we have actually come to the mainstay of this lecture. Am I audible? If I'm audible, please respond. Okay, that is Farouk Adamu. Farouk. Okay, Farouk can hear me. Can someone else second that, so that I know? Oh, thank you so much, Rabi. Okay, the whom thank you very so I'm audible. So in addressing laws or legal framework, we will always have recourse to the ground norm. The ground norm is the supreme law of the land. And what is the ground norm? The ground norm is the 1999 Constitution of the Federal Republic of Nigeria as amended. 1999 Constitution has certain salient clauses that address the issue of gender-based violence. Now, worthy of note are three sections, or let's just basically two sections, because these are the two most important sections that address gender-based violence. Section 34 is the first one, which says right to dignity of the human person. Now, we all know that there are certain rights that are referred to as fundamental. They are fundamental because you cannot separate an individual person from these rights. They are called fundamental because they are inalienable. What that means is the mere fact that you're a human being, these are natural rights that come to you, and these rights are inviolable. In other words, must not be violated. And one of such rights is the right to dignity of human person. You've often heard people say, you can insult me but you cannot take away my dignity. Because if one takes away our dignity, if one's dignity is taken, what that supposes or presupposes is that your essence is gone. What is then the essence of living? Life becomes brutish and cruel, isn't it? Apologies to Thomas Hobbes. Life becomes meaningless. Then it plunges people, to want to commit suicide, isn't it? So it is a very, very, it's in law, we call it sacrosanct. Sacrosanct means it is so it is so pure, it is so pure. There is that chastity, that level of purity that it must not, it demands that that should not be corrupted, so to speak. And so that's what it means. So when we abuse people, when we subject people through these forms of gender-based violence, it speaks to the heart of what, of their dignity, their dignity as human beings, and that is a right that must not be infringed. Then we move on to the second right, which is section 40, which could be found under section 42 of the Nigerian Constitution, which says the right to freedom from discrimination. Now, if you look at the Nigerian society or the Nigerian state, let us not forget that these rights, these rights that we have domiciled in our constitution were adopted, from international instruments that became universally applicable by virtue of the fact that Nigeria is a signatory to these treaties, to these international laws. Nigeria has also consented to these international laws, treaties, or conventions, and as a result, there was need for Nigeria to domesticate them. So these are fundamental rights, and the right from freedom of discrimination is sacred, is also inalienable, it is invaluable. No man, no woman deserves to be discriminated against along the lines of sex, religion, ethnicity, what have you. Everyone is what is equal before the law. The law sees everyone as equal. No one should be discriminated against. Even where certain infractions of extant laws are noticed or detected, the law still prescribes procedures and ways through which or with which these offenders should be prosecuted. It is an offense for us to take laws into our hands by resorting to jungle justice, by resorting to discrimination of these persons. Now that we know these are the two key relevant clauses in the Nigerian Constitution, we should also know what constitute our rights absolute in themselves, or what. When we say rights, fundamental rights, whether they are political rights, social-cultural rights, and what have you, are these rights absolute in themselves? What that means is that are these rights, do they have limitations? The answer is yes. But I'm going to be very explicit, or I will shed more light on why I think it is yes. It is yes and no, rather, and I'll explain why. If you look at the point on this slide, it says limitations due to non-justiciable social rights, right? Now, when a right is said to be non-justiciable, it means that right, you cannot enforce it in any competent court of law. It means you cannot go to court today and say XYZ has violated my rights, isn't it? And that can be found under the non-justiciable clause under section 6 sub 6C, if I'm correct. Yes, if my memory serves me right. However, there is a judicial authority that says that even though some rights may be non-justiciable, the moment a law is enacted by the National Assembly or by the legislature, prescribing the justiciability of that particular, prescribing the nature of that right, as well as spelling out offenses, that right becomes justiciable. A good example of that is education. Under the Constitution, education is not justiciable, isn't it? And when perpetrators of gender-based violence resort to restricting the victim from accessing quality education, that could also be a form of control. Education is now justiciable. Why? Because there is a case law that has made it so. There are laws, extant laws, Universal Basic Education Act, and some other instruments have made the right to education justiciable. So that's basically what I mean. So anytime you come across the concept of non-justiciability, it means those rights or the subject matter itself cannot be enforced in a court of law. But I've told you now, don't be carried away, because this is the master's class. Whenever anybody says certain clause in the constitution is non-justiciable, let that person know that regardless, the moment the National Assembly moves forward to enact a law criminalizing an offense and spelling out punishment or stating that certain things or rights are enforceable, it therefore makes that particular subject matter justiciable. I hope that point is well noted. So we go straight to this is the supreme law. So there are other extant or statutory laws that we have in the country. So we'll move on to the next slide. The next slide, please, that has the criminal and penal codes. We've moved straight to, I think we're missing the slides. Okay, thank you very much. Now, another key instrument or laws that we have are the criminal code and the criminal and penal codes. In a previous class, I had taken my time to explain what the criminal code is. The criminal code is the body of law that governs, criminal matters that in the southern part of Nigeria. Nigeria is divided into two criminal jurisdictions. One, we have the criminal code jurisdiction. The criminal code jurisdiction covers southern Nigeria. Southern Nigeria, refers to the south, south, southeast, southwest. Which other one am I missing? South, south, southeast, southwest constitutes the south. Then, in the entire southern region, the criminal code is the applicable criminal law. And this criminal code also makes the violence against persons, it prohibits any act, especially when it comes to violence against persons or gender-based violence in it. The penal code, on the other hand, applies mainly to northern Nigeria. And if you go through the penal code, there are specific clauses that address the issue of gender-based violence. However, regardless of the fact that the criminal code and the penal code have sections or have clauses that seek to address rape, assault, indecent act, and all of that, they are still limited in terms of certain areas. For example, under the criminal code, rape is recognized, but only to the extent that it applies to what? To male victims. Because under the criminal code, the criminal code does not recognize women or female offenders. It only recognizes male offenders, thereby making it seem like only females will always be the victims, while the male gender remains the offender. On the other hand, the criminal code still recognizes the same thing. So both the criminal code and the penal codes do not have holistic legal frameworks or definition of certain offenses, for example, rape. Now, when we talk of gender-based violence, don't forget that, yes, while we agree that women and girls are more often or are almost always the victims, it also does not precludes the plight of male victims. The male gender also are victims of this menace. So when we focus solely on women and girls and de-emphasize or even not even talk about men who are victim or boys that are victim, it makes the discourse imbalance. It even makes the administration of justice in itself incomplete, because justice is meant to be what? For all. It's justice for all, irrespective of persons or gender. And so if we take a good look at this criminal frameworks that I have identified in the North and in the South, they are limited in terms of scope of definition of certain offenses. And I've just given you an example of rape. But I'm sure to a great extent they agree on other. While they have points of convergence, they have too many deficiencies that we can identify. Let's move on to the next slide, please. So, no, the next slide should be violence against persons. Good. Now, in acknowledging the deficiencies that exist in the criminal and penal codes, the Violence Against Persons Prohibition Act was enacted to address these loopholes. Now, let us be clear, the Violence Against Persons Act is an organic document. By organic document, I mean it is work in progress. It still hasn't really answered all questions, but at least for the most part, it has leveraged, the mistakes, or loopholes inherent in the penal and criminal codes to making these particular offenses more broad-based. For example, the issue of rape under the VAPA, which is the Violence Against Persons Act, has been broadened to include even both. In fact, it is neutral. The Violence Against Persons Act is neutral. Under the VAPA, you could have male offender as well as female offenders of rape, amongst others. So we've seen women brutalized men. We've seen women brutalizing men. We've seen men brutalizing women. We shouldn't just go to sleep and conclude that yes, men are the only ones battering the feminine folk. But of course, I do admit and acknowledge that when it comes to physical strength, when it comes to the vulnerable group, women and girls are the most vulnerable group. That is widely acceptable, especially in crisis situations, in war-torn, countries. More often than not, you see, the women and girls or the girl child as the victim of this. So VAPA is also a response to the vacuum that exists in the previous laws that I've cited. Now, how would this play out? Let's go to the next slide, please. Now, considering the fact that VAPA is said to be broad-based and addresses, several other issues beyond rape, it also addresses the issue of domestic violence, harmful traditional practices, even emotional abuses, going further to spelling out penalties or sanctions against offenders. Do we have the VAPA, as it were, applicable everywhere in Nigeria? The answer is no. While I agree that Abuja that's the FCT is the emanating jurisdiction, is the jurisdiction of origin where the VAPA emanated. From recent research that I made, it was said that 34 states have domesticated the VAPA. What that tells you is that as against the old order or the previous situation where you had just the FCT as the only jurisdiction in which this particular law, very important legal framework that can address this issue of gender-based violence squarely, does not enjoy universal application. But right now, 34 states in the Federation have domesticated the VAPA. Out of these 34 states, five states among these 35 are yet to have governor's consent. As the governor is yet to consent to these bills in order to make them law in their respective states. But one of the milestones of the VAPA and its attendant domestication across these states that I've mentioned is the fact that victims now have broader options in seeking redress where their rights are being infringed, especially when they are victims of gender-based violence. The laws are not only there now, the VAPA has enhanced, the legal mechanism within the state, giving it the capacity to deal decisively with issues bordering on gender-based violence. So it is no longer a function of non-existent law or inadequate laws. The laws are now have now been put in place to address the menace. However, have victims or the society taken full advantage of this law? We shall find out in due course. Now, another law or statutory act that we can say has provided some level of protection and prohibition against gender-based violence is the Child Rights Act, popularly known as the CRA. Now, the Child Rights Act it cannot be said to be a controversial legislation or law in the South generally. Why? Because of the cultural practices that we can refer to as unified and more Western. It's tilted towards Western values, Western norms, and all of that. When it comes to the child, that's the well-being of the child, and the child in this case, not just the girl child, the child, both boys and girls, right? But if you look at the north, the northern region, that's why I'm saying that this particular piece of legislation, it's a bit controversial. Why? Because of the socio-cultural and religious context that have come to define the interpretation and acceptance of these laws. For example, what constitutes the age of majority in a child in the South? The benchmark or the standard with which a child is said to be, an adult is different from the scale or standard being used in the North. In the South, a child is not an adult until the child is 18, 17 to 18, but basically 18, because you have the preteen, teen, and early adult, you have adolescent, early adult, and all of that. But there is this widespread of adherence to this principle in the South. Why? Because our ways and practices are largely influenced by Western norms and values. And we're talking about being Afrocentric here, isn't it? But if you look at the North, the age of majority of a child is not determined by numbers, but by biological phenomenon, right? Which means if that child has attained the age of puberty, it is in that context that child is said to be what? An adult. Now, look at the difference. At least we've seen news headlines that made the rounds in the past, where certain prominent figures in the North were said to be married to what we would term naturally in the South as underage girls, isn't it? But if you go through their own lens and understanding within their own context, it is not child abuse or it is not underage marriage. But this law, this piece of legislation, the Child Rights Act, prohibits it, thereby making it a controversial piece of legislation. So we'll move on quickly to other important relevant laws that seek to address gender-based violence. We have the Trafficking in Persons Prohibition, Enforcement and Administration Act. Now, this law is a piece of legislation that also addresses the issue of sexual exploitation, trafficking of women and girls. The most recent reference I can relay my hands on is the case of these, I think, 16 or 15 girls in Ghana, most of whom were transported or trafficked from Imo State to Ghana for what? For prostitution, for commercial sex work. And when the investigation got there and the whole syndicate thing was busted, these girls were interviewed. None of those girls within the context of the South had attained the age of majority. Most of the girls, are, at least from the counts that I had, there were, of the 15 girls, 13 were below 15, used for what? For sex, for prostitution. And the worst part was that the customers will come, make love to these young girls or these girls, and what happens? The money, being made from the illegal or illicit business is not given to them, but their traffickers are the ones who keep the money and use it for their own purposes. Now, whether these girls consent or not, under the Child Rights Act, a child cannot give consent. And that is why if you look at how rape is defined under the criminal code and the penal code, a child, even if a child said, come, make love to me, the child cannot be said to have given what is the child, legally speaking, does not have capacity to give consent. So even if those trafficked, adolescent girls had consented to being trafficked to Ghana and understood what they were going there to do, it still doesn't make it right legally because it still constitutes an offense. I hope you're following. So these are the laws that have been put in place to ensure that these things do not happen, but they still do. Of course, we'll come back to the reason why these things still persist. Now we go to sexual harassment in institutions. Now, if you look at our institutions, our citadels of learning, our citadels, not just citadels of learning, even institutions generally, but more often than not, are citadels of learning. In institutions, you could have even the religious institutions, you could have the educational institutions where all forms of sexual harassment, even most recently is a parliamentary institution, the National Assembly. I'm sure we are all very conversant with the Natasha, what's his name now, the Senate President's saga, sexual harassment. So is there. Even in some places, it is seen as the norm. But please just pardon the slide, the first point that says no standalone national law on sexual harassment. We have some laws. In fact, we have a law currently that seeks to address sexual harassment, but that national law restricts it to institutions and the workplace. These two places are the two places that this law, the law on sexual prohibition of sexual harassment in institutions, schools, and the workplace. That law exists. I'll make it available upon request, or I'll make it available to the coordinator so that he can share with you. So we have standalone laws. In fact, the most comprehensive of this law is the law of Edo State. Edo State looked at the loophole in that national legislation that restricts sexual harassment in citadels of learning and the workplace to covering even the marketplace. That's how radical the Edo State law on sexual harassment is, including the marketplace, the streets where ladies walking and you could see, she being subjected to all forms of sexual harassment, whether she's decently dressed or not. She's constantly, a subject of what? Of sexual harassment. Edo State law for now remains the most comprehensive law on sexual harassment. However, it is restricted to Edo State. So we do have standalone laws that address the issue of what? Of sexual harassment. I've stated that of the national law on sexual harassment in tertiary institutions and the workplace, and I've also cited that of the Edo State law on sexual harassment. Other states have their own laws, but not as comprehensive as these laws that I've mentioned. So, and I think that seeks to address the other points, being covered under the slide. So, can we move on to the next slide? So let's look at the enforcement and reporting mechanism. When we have the Nigeria Police, that's the gender desk. The Nigeria Police are also known as the gender desk. NAPTIC, I just cited a good example of what that law does and what it seeks to curb in the Nigerian society or state. We've looked at the human, then there is the Human Rights Commission, and the Human Rights Commission happens to be the most popular, the most sought after. Every little thing that happens now in terms of domestic violence, in terms of gender-based violence, all forms of, violence that, may have been perpetrated against a victim by an offender, the Human Rights Commission or the Human Rights Agency in the state is almost always the go-to institution for enforcement or reporting, right? And we have what's called the protection orders under the VAPA. VAPA also provides what is known as protection orders. This protection order can also be found under the Lagos State law on domestic violence. Now, there are other, civil society groups whose object is centered on gender-based violence. And one of such civil society group or NGO is known as the Mirabel Center. There are several others, not just several others. You could even start one today, haven't been conscientized or educated further on this. Now, these are the basic enforcement and reporting mechanisms that we have in Nigeria. Man, the question you and I need to ask ourselves: are these laws or enforcement, are they very effective? What are the challenges? Now that we know, what then are the challenges? Next slide, please. What are the challenges? We have laws. When people say that Nigeria does not have law, we don't have law. We do. We have laws, copious laws. The thing is, these laws, most of them are dormant. And most of them are also largely untested. What that means is they are. I'll explain both. Dormant. A law is said to be dormant, where after its enactment and consent by the executive is passed into law, the judiciary, it has not found its way into the judiciary for litigation purposes or for conflict resolving purposes. It is not a law that is often referenced for the sake of prosecution or enforcement of rights. Are we together? So that's one of the challenges, and why we have cultural norms and stigma. For example, I think we discussed in the previous class here that let's assume a woman comes with, okay, let's just forget about the woman now, a man in this case, because the focus is on gender-based violence. Imagine a man walking up to any of these enforcement and reporting mechanism, reporting that he's been sexually harassed by a woman. How do you think this male reporter would be treated or perceived? I remember a research I did on this same subject matter, where the issue of male victims of GBV is largely underreported as a result of these cultural norms and stigmatization, especially against the masculine gender. That's male victims. So let us restrict it to the male victims now. They don't go. But what about the female victims? Yes, chances are female victims are mostly the ones who go to report, but on selective cases. But when it comes to rape, most of them would not want to come out because of what the society will say. You know what people say about a lady that has been raped, the myth erroneously at that she will not be able to, find a woman that has been raped, whose name or identity has been made public. Chances are she won't end up seeing any man that will be interested in her. And so many other, defective myths that surround this particular, subject matter. So many of them. We have low reporting rates as a result of this same thing. You also have poor enforcement and prosecution due to the fact that the justice system is porous and corrupt. It's very, very hard to find incorruptible judges. No, they exist. Please don't quote me, please. We have judges that are incorruptible. We have prosecutors that are incorruptible, but they are hard to find in Nigeria of today. Because the justice system is designed now in such a way that only the rich would always have their way and go scot-free whenever they commit offense. But it's not the case with the poor. So it appears as though that the laws are designed for the poor, not the rich. But of course, you should know it's not in all cases.
Right.
So,
Barrister Chima, hello. Sorry to interrupt. There's a question in the comment box, and our time is like 10 minutes more to wrap up and your Q&A. Somebody says that some of these groups are ready to war, but are put under threat. That's what this person said. They whom? Are you a lawyer? This person said that. Said they are constantly put under threat. What do you mean by that? Do you want to expatiate on that? So we are going to the last part of the presentation.
I would suppose that the purpose of that question is the kind of object that these NGOs pursue could be dangerous, especially when the offenders are very powerful people or people of means that can deploy the machinery of state against them, if I'm correct. But of course, that comes with it. It comes with the hazards of the job. It's hazardous, right? Every vocation, every cause has its own hazards, and this one also comes with advocacy. or championing rights of people or defending people's or public rights. So you would always have such threat, but if you're bold enough, if you're grounded and you know the right sources to explore, chances that these threats will be eliminated, especially if you know how to make good use of the media and of course law enforcement agency. But then if the battle is against the state, in most cases I would advise that if you don't have the capacity, you just have to fight from outside. So I quite understand where that is coming from. So to just summarize, the entire presentation. Laws exist. Gender-based violence lives with us. Survivors, the slides have some recommendations, okay? Recommendations like survivor-centered justice approaches. We know what that means is these conflict resolving mechanisms or institutions should be survivor-centered. Whatever instrument or mechanism that is going to be designed or adopted should be centered on the plight of survivors, isn't it? But don't forget, life is a two-way traffic. Increase funding and support services. Of course, now that some of the activities being run by NGOs is being cut off by virtue of the cessation of the US aid to most African countries and beyond, countries have to now look inwards on how they can identify certain causes that affect their own common heritage. Gender-based violence is one of it. So government should look towards supporting the cause so that people who are championing this cause, especially those against gender-based violence, can be supported going forward. Then finally, adopting an Afrocentric approach that teaches care and respect for women. We can't even overemphasize this. Our boys should be socialized on how to treat women with respect, but I also think it is vice versa. Women too should be treated, they should be socialized beyond their traditional roles to also see men as partners, not just their lords, not just their feudal lords or their demigods, but as partners. And even when they have more means than their male spouses, they should be socialized in a way that the man would not be made to feel emasculated as a result of not having the means to take care of his home. And that, in addition to others, are the recommendations that this lecture has presented. So in a nutshell, we all know that gender-based violence is a violation of human rights, and Nigeria has made progress, but more work needs to be done. And you and I, beyond the government, will be the ones to bridge the gap. And one of the ways we can do this is not just having the money, but using our mouth publicity. Let us teach it. Let us intervene whenever the need arises, without waiting on NGOs or the institutions of states saddled with the responsibility to fight against it. You and I have a role to play in bridging or in fact to eliminate this scourge from society. And we should also learn to test the law. Beyond being passive commentators, advocates, let us also go and let us test these laws. If there's anybody who feels marital, for example, does not exist, it does exist. The laws recognize it, and we can test it for the first time in our Nigerian system. And the moment that is tested, it becomes what judicial precedents for others to follow. So thank you very much for your time. And I hope you've learned a thing or two, and I'll be willing to field questions from the floor. Thank you very much.
Thank you, Barrister Chima. This is a fantastic presentation. Erudite lawyer, thank you so much. So let's take one or two questions now. Then we have someone to give us a bit of time. Okay, Queen, we do that. Let Queen do that. All right. Thank you so much. Thank you for managing the time. All right. Any question or contribution? This is more our law. Okay. This Queen says that the people that make our law also violate women. That's true. That's true. That's what we are saying now. How will they make sure that we implicate them? That's true. All right. So, Queen, do you want to give vote of thanks? Any question? We have some lawyers in the training.
Sorry, the people that make our law also violate women. I agree. Sorry, I just wanted to address that. All right. I just wanted to address that. But the moment we narrow this conversation down to women as victims only, it makes the women even look weaker. Women should be empowered beyond, being protected. The social schemes, the welfare scheme should be opened up and the patriarchal system should be dismantled within corporate settings. I'm not talking about social religious context or settings, within corporate settings or setup, especially politics, such that women should support women and, you know, ensure that they have more representation. For example, women constitute 54%, if I'm not mistaken, of Nigeria's population. So they are not passive stakeholders in the country. I hope I've answered that question.
Yes, you have.
Yeah, because I'm sure you saw the video where a woman was violating a man. And I don't want to start talking about what a friend of mine shared with me last week. He said now he remembered what happened to him when he was 6 or 7 in his compound, where a woman would invite him into his house, into her home, and start fiddling with his genital, with his male organ, and make her go through some kind of sexual satisfaction. And that a boy child being violated by a woman, a full-grown woman. These things happen silently, but boys will never come out. More than not won't come out. So if you look at the Vapa, that is exactly that is why I think